All right, the topic of today's discussion is the Asset Protection Trust. And for some of you, I'm seeing some familiar faces and some familiar names on the call today. And for those of you that have seen other seminars in the past that give a good overview of estate planning documents from the basis, from the basics, and then also talking about some more complicated and some trust funding mechanisms. Today, we're just going to talk specifically about trusts, and even more specifically, trusts that we use to protect your assets from creditors or long-term care. All right, so here we go. Well, first, a little bit about me. So my name's Landon Hodges. I'm born and raised Mount Airy, North Carolina, small town near the Virginia border. We'll get to how you may know that more in a little bit in more detail soon, but I did my undergraduate studies at Wake Forest University and law school at Elon University, both in North Carolina. And then I moved up here about 3 years ago and have been here ever since, and have focused primarily in wealth protection and tax planning, with a lot of long-term care planning mixed in there, which of course Kristin helps me there. Then also anytime somebody needs litigation services, which are rare in most cases, but whenever court is needed, I'm usually one of the points of contact for that. So now I reside in Jersey Shore, Pennsylvania, and make frequent trips between both our Williamsport and our State College locations. But yeah, so I mentioned Mount Airy, North Carolina, and most of you may know that by its television name, which is Mayberry. So this is the town that Mayberry from the Andy Griffith Show is based on. And as you can see there, you know, there was an idea for a young attorney to be in the show originally, but you don't see me in there anymore. And what I'm thinking is that Andy Griffith may have already had ideas for Matlock, and he didn't want me stealing his thunder. So it was just Andy and Barney there for a while, and that's kind of how most people know of my small town down there. But with me today is Kristin Daugherty, and I'm going to let her take over and introduce herself to you.
Thanks, Landon, and thank you everybody for joining us today. It's such a beautiful day outside. Matt was wrong. I'm actually home today. I'm glad I fooled him though, and I considered sitting outside and enjoying the weather while we chatted today, but there's a lot of kids roaming the neighborhood, and I thought that might be a little distracting, so I'm enjoying the air conditioning. So just a little bit about myself before we dive in today. I am a certified Medicaid planner and a long-term care planner with the firm. So I work primarily with our pre-planning clients and more specifically with our crisis clients. So our clients that need care themselves or a loved one that needs care. So I work along with the attorneys like Landon to make sure that we're covering all the pre-planning and the crisis needs. I'm actually also a certified dementia practitioner. Back before COVID started, which seems so long ago, myself and Julie Steinbacher traveled out to Arizona, where I also became a certified Alzheimer's disease and dementia care trainer, which means that I actually am able to train other individuals on becoming a certified dementia practitioner. We had hoped to be able to do some of those trainings so far, but that's also been put on hold since they are needing to be face-to-face trainings. So I definitely focus a lot on dementia and making sure that families have everything that they need to as they go along that journey. So today, Landon's going to jump in. He's going to get us started and talk about the Asset Protection Trust. It's interesting, this seminar is always one of our most popular seminars that we do. So if any of you joined us for previous seminars that Landon and I have done, or Tammy or Brittany have done, you're gonna notice there's going to be some overlap in the content, and that's because a lot of what we talk about in these seminars is so important that we just have to repeat it and talk about it a lot. But today we're really going to focus on the irrevocable trusts, how they work, why they work, and then after Landon talks about the trust, I'm going to come in at the end and talk a little bit about how that plays into if you need nursing home care and gifting and the 5-year look back. So Landon, why don't you take us away?
Wonderful. Thank you, Kristin. All right, so let's start with the simplest question, or hopefully simplest question, is why are you here? So as we both mentioned previously, we do several seminars throughout the year, and a lot of them cover the basics and talk about trusts a little bit. So today I'm not going to be talking about wills and powers of attorney really at all, because I want to dive deeper into the topic of trust because, well, I find it more fun anyway, but it's also the most confusing. So you're here today to have this discussion with me and learn more about the asset protection trust specifically. Now, if you do have questions about the basics, so wills, powers of attorney, you should absolutely contact us because those are very important. But we're going to, I guess, the next step there, I'm going to go a little bit more detail about specifically trust that can be used as part of your estate plan. So going on with that question of why are you here, how would we use this type of trust? So again, this type of trust protects any assets that it holds. So it can protect property or assets for yourself, to be used at some specified event or for some particular purpose down the road. Or most commonly, it's to hold and protect assets so that they can be distributed to your children or other individuals or entities when you pass away. While you're alive, one of the main benefits of having this type of trust is that it prevents a nursing home or the state from benefiting off of all of the money that you've worked so hard to obtain. At the end of the day, you're here because these assets are yours. You've worked hard for it, and you deserve to have a say in what happens to it when you pass away. So one common misconception about trust is that trusts are only for rich people. And that's, of course, there are types of trusts that are most beneficial to people of very, very high net worths. But there's a lot of different trusts out there, and they all are designed to cover different needs. So having a lot of money or federal estate tax, which is where you hear that type of stuff, that's one use of a trust, sure. But a trust is for anyone who has assets that they consider worth protecting from their creditors or from the eventual cost of long-term care. Trusts can be established with any amount of money or real estate. And so you don't have to have a minimum amount of assets to put in there. So while of course a trust that only exists for federal estate maneuvering is not going to work for many people right now, don't dispel with the whole idea just because you may have heard that there are types of trust out there that are only beneficial to high net worth individuals. It works for everyone, regardless of your circumstances, and it's a great benefit to have in your estate planning toolkit. So why should you consider it? So you'll hear some terminology thrown around here. Asset protection trust is really an irrevocable trust. So at its most basic level, the irrevocability of it is that once it's established, you do not have the power to just snap your fingers one day and say, I want to get rid of that trust and take everything in it and go on a big vacation. Because of course, as we'll get to later, if you have the power to do that, a creditor or a long-term care facility down the road would have the power to force you to do that. So the irrevocable trust is that it exists separate from you, and we'll get into how the powers that you can have to control the assets later. But the irrevocability of it is that you can't just get rid of it on a whim. But the irrevocability of it allows you to transfer property or assets into there, have them held separately from you so that they're not part of your personal countable assets, but you can still retain control over them. What you're working with an irrevocable trust is your access, because anything that you have access to, a creditor could access. But control is separate, and we'll get into how that works in the context of a trust soon. But essentially, this type of trust protects any assets that it owns from your personal creditors or eventually cost of long-term care. So once assets are distributed into the trust, they're not subject to a estate recovery lien from the Commonwealth of Pennsylvania or any other state. The cost of nursing home care, if you need that down the road, they can't force you to get money out of the trust to pay those bills. And on another note, they're not subject to the creditors of your beneficiaries. So I'll talk a little bit more about this later, but a lot of people ask me, why don't you just transfer the assets directly to your children? And the answer to that is that, well, once it's theirs, it's theirs. So if they die, get divorced, have a lot of debt, or become disabled, your assets are now theirs. So if they run into the same issues that you're trying to avoid, then you might end up back where you started with if it's in their hands. A trust is the greatest middle ground because it holds the property completely separate from all individuals involved. So they're not titled in your name, they're not titled in your children's name. They're titled to the trust, and the trust sets the rules for how they're managed. So that was the benefits of while you're alive. Now, let's look at the benefits from after you pass away. Any assets that are in a trust avoid probate. So that's the process that after you pass away, your will needs to go to the courthouse and begin the formal probate process. There are fees associated with that process, and it's a public process that takes place at the courthouse as a matter of public record. Trusts and any type of trust completely avoid that process. It also allows for controlled gifting. So once assets are in a trust, you have the power to customize that trust when you make it to add any specifications you would like as to when and how your children or other beneficiaries receive that property. While there are some disadvantages such as your access to the principal, you can still set the rules as to how this gift is controlled, when people get it, how they get it. And then it also allows you to manage those assets. They're fully customizable. So no matter how creative you've gotten whenever you're thinking about how you want your estate established, a trust is a great way to customize it and really make it personalized to what you want. And then, of course, for those who are in asset brackets to have to deal with federal estate tax, trusts can greatly reduce your exposure to federal estate tax. But what we're mostly talking about today is asset protection, not as much federal estate tax, because as of right now, that only affects assets above 11.58 million. So for most of us, that's not anything we have to worry about. And for those who do, give us a call, but there are certainly worse problems to have, I suppose. But yes, so I mentioned earlier about the trust being able to protect your assets from your beneficiaries' creditors. So one of the old ways of planning for nursing home care was just to reach a point where you deed your house or your other real estate just directly over to your children. Now that method is correct in that it does remove the asset from your estate. But what you need to watch out for is what happens in your children's lives. Life happens to all of us. You cannot be certain what happens. So this really boils down to the risk there boils down to the 4 Ds. That's divorce, debt, disability, or death. So if your children own your house, for example, and they pass away before you do, we all hope that would not happen, but unfortunately it does. And if they were to pass away before you, your house is now going through their estate plan, and you have no control over what happens to it at that point. So putting it in your children's name, yes, it does get it out of your estate, but there are some inherent risks there that can be completely avoided through an asset protection trust. And here's a little cartoon there. So hopefully there are no issues with the trust in your estate plan, but if your spouse tells you that there are trust issues, hopefully it means you need to give me a call and not a marriage counselor or anyone else you'd hire for that particular purpose. I can only help with one of those as well. So if it's the other type of trust issues, I'm not going to be your best point of contact for that. So I wish you well there, though. All right, so let's go back. So let's back up a little bit. Let's go back to the very basics of a trust. So what exactly is it? At its most basic form, a trust is created when you set property to the side to be managed by someone else under a particular set of rules. So, and this is not valid under the law anymore, but under common law, if I gave you $10 and said, hey, hang on to this until I retire and then give it back to me, technically that would have been a trust because the money is set aside under a particular set of rules, returned to you when you retire, and the person that's holding it is in charge of managing it until then. Now, of course, things are not that simple now, and it does have to be in writing. But basically, the trust itself is a legal document that sets the rules under which property would be held. Now, it does not necessarily have to be someone else that's managing it. The trust would name the trustee, which is the person that's in charge of managing the trust. Now, in this particular type of trust, you can be your own trustee. And the trustee manages any assets that are in the trust. So you can buy, sell, and trade real estate. You can make investments of trust assets. You can buy property with money that's in the trust. You're really in charge of managing it with all the powers that you would need to do that. Now, in order for it to protect you, you can't have the power to distribute assets to yourself. Because again, like I said earlier, if you can reach in there and pull something out, a nursing home or a creditor can make you do that. So what's the solution there? The trust names a trust protector, whose only job is that they have the power to make distributions out of the trust to trust beneficiaries, which are people named in the trust document that are allowed to receive distributions. And so that's a way to make sure that you, the person who's funding the trust and are trying to protect your assets, aren't in charge and don't have the power to pull it out or give it to people. You're giving that power to someone else. If you think of the trust like a house, then think of the trust protector as someone that has a key to the back door of the house, but you can, to ensure that you don't have that key, because if you can access it, your creditors can follow you in. So the person that sets up and funds the trust with their assets is referred to commonly as the donor, but things to watch out for in this area of law is that they go by several names and they all mean the same thing. So you might see donor, grantor, I've seen trust maker. There's a common one that I'm missing right now, settler. Donor, grantor, and settler are the three most common ones you see. But whether you see one or any combination of those terms, just know that they all mean the same thing. It's the person that's setting up and funding the trust. Now, separate from the grantor, and as I mentioned, it does not have to be a different person, but it is a separate role. The grantor or the donor sets up the trust and puts assets into it. Once the trust owns assets, the trustee is the one that's completely in charge of managing them. And now management, of course, let's use real estate as the easiest example, because that's probably the best example of what maintenance looks like. So you sign a deed, the trust now owns this real estate. And as with any real estate, there's costs to maintain that property. You have to keep insurance on the property. And of course, you have to pay your property taxes. Once the property's in that trust, the trustee is in charge of making sure that all of that is done. And then, of course, if you do have some liquid assets in the trust, the trustee has the power to invest that money and to make sure that it's managed properly or managed by a trust department at a bank. Now, so we went over two roles. We've got the donor or grantor and the trustee. So in our particular asset protection trust, we have a role called the trust protector. And again, they only have one job, and that's that they have the power to pull money or assets out of the trust if needed. The trustee or grantor cannot control them. This is an independent role, but the donor does have the power to choose who is the trust protector and can change the trust protector in the future. So while they do have the power to gift trust assets to the beneficiaries, the donor can't control that. But consistent with the power that I mentioned previously, they can't make the trust protector do anything, but they can fire the trust protector. So that's as close as you can get to the assets. But if, for example, the grantor would ask the trust protector to give some money to a child, for example, the trust protector says no, the grantor can't go in there and do it themselves, but they can remove that trust protector and then appoint someone else in that role. And as long as it's not the grantor that's making distributions from the trust, then all assets in there would remain protected as long as they're in there. So I've talked about the property being in the trust and how the trust protector, once it's in there, only has access to it. So when does it actually pay out? So typically, a trust would terminate when the donor or both donors have passed away. So say you're a married couple, you set up a trust to protect your house from long-term care. Most commonly, what you would see there is that that trust would exist until both you and your spouse have died. And then upon the second spouse's death, the trust would terminate, and the trust will have a built-in, more or less a built-in will to it that will say, once the second of us dies, the trust terminates and all assets in the trust pay to our children or whatever beneficiaries you want to have in there. Again, the grantor of the trust has the full power to choose what happens to it when they pass away. There are other types of trust, and Pennsylvania allows for what's known as dynasty trusts that do not terminate when you pass away. So I do these a lot for families that have maybe a family cabin or a family hunting ground that's more sentimental in value, but it's very important to them that it stays in their family. And they kind of do want to have some rules in place for what will happen to that property when they pass away. So these asset protection trusts can have the full benefit of protecting assets while you're alive, but then they can continue even after your death and set rules for how property is distributed and held and managed for an indefinite period of time after your passing for the benefit of your descendants or whoever that might be. Again, it's very customizable. So anytime you hear me using very general terms such as your beneficiaries, it really is completely up to you. That's one of the beauty of trusts, is that I'll make sure that it legally does what you want it to, but then other than that, it's really customizable. So who decides what goes into it? So typically the donor would make those decisions. But one important thing to point out is that the trust doesn't do anything and it doesn't own anything until you actually transfer ownership of assets into it. So just because you signed a trust with an attorney doesn't mean that it does anything until you fund it, until it actually owns something. So that for real estate, that can be done through a deed. So you actually deed your property from yourselves to the trust. Or for financial assets, it would need an account, whether that's a simple checking account or an investment account, owned in the name of the trust. But once it's all moved in there, the trust owns it. Any benefits that the trust is set up for are realized at that point, and then the trustee is in charge of managing all of it. So what can you transfer to a trust? Well, I talk about real estate a lot, and that's probably the most common one and one of the easiest things to protect. But you can also put most annuities in the trust. You can put simple checking and savings accounts, life insurance policies, investment accounts, bonds, individual stocks. Most assets, except for some exceptions that I'll talk about on the next slide, can be moved into a trust. But the thing to keep in mind, though, is that they do have to actually be moved. Just signing a trust is not enough. To protect those assets, you have to move them in there. So the few things that cannot go into the trust, and some of these, for example, so retirement accounts are the top one. And this one, it pains me to advise people sometimes because I work with a lot of families that sometimes they've worked their whole lives and the largest asset in their estate is a retirement plan. And there's nothing wrong with that, but it certainly does make planning a little bit more difficult because retirement accounts, while there's nothing legally preventing them from being moved into a trust, but with a retirement account such as a traditional IRA or a 401k or a 403b, if you change the owner of that account, that would be a taxable event. It would be the exact same thing as withdrawing the entire account in your name. And since those are qualified accounts, that event would make the entire account taxable income in that year. And so I'm certainly not in the business of creating tax bills for anyone. So what we do is we work with the attorneys and long-term care planners in our office to make sure that there's a plan in place to save as much of your retirement accounts as possible. But unfortunately, that's not an account that you can just transfer into a trust. Vehicles and mobile homes are also ones that do not get transferred into a trust like this. And that's because they are individually titled assets, and the state makes it very difficult, if not impossible, to actually move them. But with vehicles and mobile homes, those usually do not create much of a problem when it comes to long-term care planning or asset protection. But I do get that question quite a bit of, should we title the cars in there? And that's usually not anything to worry about in relation to the real estate or the larger assets of the estate. So yeah, and we've touched on this earlier, so I'm going to skip through this quickly. But again, the advantages are protection overall for the assets that are in there, whether it's nursing home care while you're alive, estate recovery after you die, or anything that could happen in your children's lives. The things that are in this trust are protected. So now I mentioned this earlier, but the disadvantages of transferring assets into the trust is that you as the donor don't have the direct access to just reach in there and do whatever you want. So let's look on the opposite side of it, juxtapose that with a checking account. Your personal checking account, that's your money. There's no strings attached to it. You can reach in there, do whatever you want. You can, and that is yours to do as you please. Once you transfer assets into an irrevocable trust, the trust document controls how that property is managed. And in order to give you the protection that we seek from this type of trust, you can't have that power. But as we mentioned previously, you can give that power to someone else, the trust protector, and you can choose who it is. So for all the advantages that you get, of course, you can't get that much advantage without there being some downside. But thankfully, due to the customizability of trusts, we can work to minimize that downside as much as possible so that we can maximize your benefit while still maintaining as much control as we can without sacrificing benefits. So a favorite topic of mine, let's talk about taxes. But thankfully, not paying them, but just how they work and ways to reduce your overall taxable estate. So trusts can be grantor or non-grantor. And I'm not going to go too much into detail about this because it is very legally thick, for lack of a better way of putting it. And most likely we're going to use grantor trusts. And a grantor trust means under the IRS code that the owner, the grantor or the donor, remember those are the exact same terms, is treated for tax purposes as if they are the owner of the trust. So the donor's social security number is the tax ID, and any taxable income generated inside the trust is taxed on the donor's individual tax returns. And now in a typical grantor trust, it is still going to be subject to Pennsylvania inheritance tax, which I have a slide in a minute that will show those tax rates. But the reason that that's preferable still is because since it's a grantor trust, you retain quite a bit of power to control the assets that you would have to give up in order to avoid Pennsylvania inheritance tax. But then if you pay inheritance tax on a property, your tax basis in that property steps up upon your death, so that your children or your beneficiaries, whoever that might be, when they receive the assets in that trust, they receive it at a step up basis, so that if they ever sell it down the road, they're not going to have to pay a capital gain or much less capital gain if they do have one. And so capital gains are based on their individual income tax bracket, but usually 15 or 20% tax on the gain between tax basis and sales price. So for an asset, say for example, a property, a real estate property that you bought 30 years ago, your basis in that property is what you paid for it 30 years ago. And so if you give that to your child without paying inheritance tax on it, they adopt your basis. So their basis would be what you paid for it 30 years ago. And then if they sell it, they're going to take the sales price minus what you paid for it 30 years ago. and they're going to be taxed at about 15% on that difference. So in that context, Pennsylvania inheritance tax doesn't seem so bad in most cases. Now, there are exceptions, as with everything, but for most cases, inheritance tax is the lesser of evils. And I'm going to kind of go through this part pretty quick, but a non-grantor trust is completely separated from the grantor. You have to go through the IRS to get a separate EIN, and it's taxed at the trust tax rate for income tax purposes. So after the first $13,000 of income generated in a non-grantor trust, anything over that's taxed at 37%, which most individuals are not in a bracket to be taxed that high. So in most cases, it's very much preferable to have a grantor trust, because that means that the only income tax rate you're working with is your individual tax rates. And so that's why I'm going to skip over that now, because the asset protection trust that we're singling out today is almost always going to be a grantor trust. So that was the grantor non-grantor trust really deals with income tax, both federal and state income. But I mentioned inheritance tax in there. Pennsylvania is one of the states that has a inheritance tax, and there is no exemption to that. So, well, sorry, no exclusion. There are certain assets that are exempt, such as life insurance proceeds, but there's no exclusion. So technically, if you die with $10 in your pocket, the state owes a percentage of that based on what we see here on the screen. So for your spouse or your children under 21 years of age, that rate is 0. Note in that when I say child there, I mean yours, not just somebody else that's under 21 years old, but your child that's under 21 years old. But for most people, the one that we use is the 4.5% rate, which is for your direct descendants. So that's children, grandchildren, and so on down the line. So for most of you, when you pass away, your assets will go to your children or grandchildren, and that'll be a 4.5%. So think about what I talked about on the last slide with the capital gains taxes. If they can pay a 4.5% tax when you pass away to avoid a 15% tax down the road when they sell it, that usually works out in their favor. Now, for people who don't have children, inheritance to siblings is 12%, but then anyone else is 15%. So for people who don't have children, typically you see nieces and nephews in their estate plans. Unfortunately, that will be taxed at a 15% rate. And the charities, of course, are 0. For those of you that are charitably inclined, any assets can be sent through a trust to a charity at 0% inheritance tax. Another one to keep your eye on is realty transfer tax. So technically, anytime you sign a deed to transfer real estate, the state wants a 2% cut of the fair market value or the sales price. If you're working with us, we'll be very careful with that. But if you've ever done any trust work, this applies to trusts. And there are some exceptions, but the trust has to be carefully drafted to make sure that it's going to be exempt from this tax when your property is moved in there. So anytime you get into trust work, it's important that you're working with the knowledgeable firm that specializes in this area of law to make sure that all potential pitfalls are considered, not just the immediate goal of protecting your assets, but there's a lot of estate planning and tax considerations that need to be thought about as well. Not to mention the Medicaid long-term care planning regulations that Kristin's going to talk about, that we see a lot of people have a blind spot for that if they don't specialize or frequently work in this area of law, and that runs into problems for some people. So, okay, so on the federal level, so this slide here, this is Pennsylvania state. So this is Department of Revenue, not the IRS. At the federal level, you hear pretty much only politicians talk about the federal death tax. Well, that language is usually just meant to scare you, usually to make you vote for something that's not going to work for you. But the federal estate tax right now only affects individuals that have a net worth over 11.58 million And through a process called spousal portability, you can double that. So for a married couple, you can have about $23 million before you get hit with that death tax that they try to scare you about so bad. So once you know it, it sounds a lot less scary, but it's probably the point. So there's also a gift tax. Now, gift tax sounds scarier than it is as well, because it sounds like you're going to get taxed on a gift that you give. But at the same time, you're never going to actually owe money for a gift unless the gift is over the federal estate tax exclusion. So if you were to gift me $12 million right now, first of all, thank you. Second of all, you would have to file a gift tax return and you would actually owe on that. But for federal gift taxing, if you give a gift to somebody that's over $15,000, you do need to file a gift tax return. But unless it's over that amount, all it does is reduce the amount of your gift from your federal estate tax exemption. So if you gave me $100,000, again, thank you. But you would file a gift tax return, and the $11.58 million that you're allowed to die with would become $11.48 million. So I guess keep an eye on those checking accounts before you write that check to me. But and then call me afterwards if you want to do this, of course. But now with taxation, that's for gift taxes. Kristin's going to talk about this more. With gifting, if we're going to be doing asset protection, especially for long-term care planning, gift tax is not the gift that the $15,000 is not the number we're worried about. For Medicaid purposes, they will count or issue a penalty for any gifts that are larger than $500 a month. So I'm not going to cut into Kristin's topic there, but just know that for a lot of cases, $15,000 for gifting is the number you hear the most about, but it's not the one that we keep our eye on. That's just for federal gift and estate tax purposes. And then we discussed income taxes. Again, individual is much lower rates than non-grantor trusts. And then state income taxes actually aren't different either way. But if you've got taxable income, taxman's going to come one way or another. It just depends on how much and who's paying it. All right, so administration considerations. So let's look at wills versus trust, because of course wills are one of the basics, and even with a trust, I strongly recommend everyone having a will. Trusts are will substitutes, meaning that assets that are in a trust do not go through your will, but the trust only administers assets that are owned by the trust. If you die with anything in your name, you need to have a will in order to ensure that you have a say in where that property goes. Because if you don't have a will, the state has written one for you. So you should at least have a say in the matter. So, wills versus trusts. Pennsylvania inheritance tax is not different. If for your typical asset protection trust, you're still going to get hit with inheritance tax, just as you would through a typical will. So that won't be any different. They still both have to be paid either way, and the rates are the same. One big difference, though, is that anything going through your personal estate, through your will, has to go through the probate process, which is included a probate fee. Trusts, on the other hand, do not have any probate fee. There are going to be attorney's fees involved in the administration of either. So while trusts avoid probate, there is still some administration work that has to be done. And the next slide, we'll talk about that a little bit. But it can be done much more in-house with your family, your attorney, and not have to involve the public process of going through the courts. And then with both, so after the donor's death, the trustee of the trust who takes over most commonly would be one of your children, just like your executor. It's a very similar role to an executor. And just like with the will, whether it's through your will or your trust, your executor or your trustee is entitled to a fee, because if you've ever done this yourself for a family member that passed away, you know that there's quite a bit of work to be done either way. So we want to make sure that those people aren't taking a loss for all the work that they're putting in for you. And trust as well as wills, both of them are subject or can be contested by a beneficiary. So if a beneficiary, or in most commonly, a person who was removed from being a beneficiary who thinks they should have been a beneficiary, can contest, I guess my accent came out there, they can contest a will or a trust. So if you're worried about that, or if you know that there might be some trouble brewing at following your death, consider adding an interim or a no contest clause to the will. And what that means is that you can add a provision to a will or a trust that says that if anyone challenges the validity of your will or your trust and loses, they are removed completely. And in stronger ones that I've written, you can remove them and their descendants, so that if someone feels the need to contest your estate and try to tear apart the plan that you made, you can certainly add a clause like this to make sure that they think long and hard before they make that type of decision, to make sure they have a good case. Because if they lose, there would be consequences for it. So that's something to consider there if you think that there might be some issues brewing down the road. And so I guess so yes, trust avoid probate, but there is a similar process. It's not an immediate process. It's not something that can be done in a month after your death, because there's still tax returns that need to be done. And just like with an estate, even though it's done outside of the formal probate court process, you still have to send notices to all the trust beneficiaries. You still have to advertise the administration of a trust, and you still got tax returns to do. So even though we're avoiding probate altogether, there's still work to be done. And I say that because a lot of times, especially beneficiaries or the next generation, expects it to be quicker, or someone passes away and a month later they expect everything to be done. And unfortunately, there's still more work that needs to be done, but that's why you have knowledgeable professionals that can walk you through every step of the process. All right, so that's your basic introduction to asset protection trusts, who the players are, how they work, how to fund them, how they're administered. Now I'm going to turn it over to Kristin and talk more specifically about why we use them and how they work in the context of care and different benefits. So Kristin, I'll hand it over to you from here.
Thanks, Landon. And for everybody who, this is their first seminar with Landon and I apologize that Matt didn't inform you that you are with the two chattiest people at the firm. So we'll try not to hold you hostage here all day long. But Landon, thank you so much. That was a fantastic explanation of all the trust. And, I could talk about them, but not like Landon. And I prefer to talk about the other stuff that we're going to dive into right now. Also, as Matt mentioned, at the end of our discussion today, we're happy to take questions. I see those of you I see, you're jotting down notes, which is wonderful. I've been over here jotting down notes also. So we're happy to take any questions you have. Also, please keep in mind that our office does offer free initial consultations, and we do that because after these seminars, we know you're thinking about things that are going on in your situation, and you might want to come in and talk to us and see if you need to work on trust or some sort of planning. That's what we're here for. That's why we offer that free initial consultation. There's no obligation. You can come in and we can talk about your particular situation. So we're going to dive right back into the trust and talk a little bit about the long-term care and how the trusts really play into that long-term care. So the first question here, it's interesting. Will a trust limit my nursing home options or level of care services that I receive? Possibly. That's not a clear-cut answer. So what happens is, let's take Lycoming County, because I know we have a nice mix here of clients from our Williamsport office, State College office, from both of those service areas. Our Lycoming County nursing homes, they actually all accept Medicaid. So you could certainly private pay at any of those facilities, but you could certainly qualify for Medicaid at any of those facilities. But let's take a look at our Center County nursing homes. It's a little bit different there. Not all of the skilled nursing homes in our Center County area accept Medicaid. Some of them are strictly private pay. So what that means is if you're looking at a facility that you're going to buy into, so CCRC, continuing care retirement community, for instance, that maybe you're going to move into now when you're healthy, and you're going to buy an apartment or a condo or even a little house there. You're going to purchase price. You're going to, maybe it's $100,000, maybe it's a $200,000. You're going to buy in. You're also going to pay monthly rent, but that facility is going to take care of you in some way as you age in place. Some of those facilities don't actually accept Medicaid, and some of the clients that we work with are going to those types of facilities. So when we're working with you and it's realistic that your income and assets will actually help you and be able to sustain you in that type of facility, we might not be looking at asset protection trust because it wouldn't make sense. It would actually hinder you if you're going to move into that type of facility. But most of the time we are looking at Medicaid type facilities at some point in time. So it's always a really important thing to be thinking about. If you need long-term care, where do you want that to be? At home, in a facility? And if it isn't a facility, what facility? And I know that's really hard to think about, and all of us want to stay home. But it's also good information for your loved ones to have because it helps us guide your loved ones to make the best decisions. Okay, let's see here. So a lot of what I do at the office is really that crisis work, which is Medicaid planning. So we want to figure out if you're going to move into a Medicaid facility now or in the future, how does that actually impact you? So if we're talking about trust or any type of gifting, we always have to worry about that 5-year look back. And I always like to take a few minutes to talk about the 5-year look back because there is a lot of confusion about what that actually means. So if you or your loved one move into a long-term care facility and need skilled care, the first thing that they're going to ask you on the application is, have you made any gifts in the last 5 years? So this goes right back into Landon's conversation a few moments ago. So what is a gift? So a gift for Medicaid purpose is a lot different than a gift for federal tax purpose. So a gift for Medicaid is anything $500 or more. We're going to talk a little bit more about that today. But if you, Landon, can we go one slide forward? Sorry.
Okay.
Sorry. So if you move into a facility, and I have to tell you, I would never ever bash any of the nursing homes in our area. I work with them. Tammy, my counterpart, she works with all of them. They're fantastic. They do a good job, but they're not trained the way we are to be able to really deal with these types of issues as far as gifting and asset protection. So anybody who moves into a nursing home, they're essentially going to hand you a Medicaid application and say, here, fill this out. Well, you're going to fill it out because the nursing home told you to. The problem is most people are going to be denied because they've made gifts or there's something else going on, like they're not actually qualified for Medicaid. So that can create an issue. We don't want the application to be filed, especially if there's been gifts, because it creates a little bit more work for us or for you when we have to kind of retract and go back through that process. But let's talk specifically about the trust like Landon was talking about. And I'm going to give you some scenarios here today because I don't know about you all, but I definitely like scenarios and to see kind of real life situations that may happen. But if you file the application and there's been gifts in the last 5 years, Medicaid will probably deny the application. Or if you're working with somebody like our office, they're not going to deny it, but they're going to impose a penalty period. So what is a penalty period? So we've established that anything over $500 a month is a gift. So $500 a month can be real estate, it can be a vehicle, cash, check. Anytime you give away anything to anybody, whether it's a trust or a person, and it's over $500 a month, it creates a period of ineligibility if you need Medicaid to pay for your care in the next 5 years. So a lot of what we do here at our office is gifting, but we have to do it in a very structured way to make sure we do not jeopardize your benefits if you need them, because unfortunately, none of us have a crystal ball and none of us know when we're going to need that care. So the magic number right now in 2020 is for every $10,732.83 that you give away, it's 1 month the state of Pennsylvania will not pay for your nursing home care. So what does that actually mean? So here's a perfect scenario up if you can see on our screen. If not, I'm going to go through it. So a lot of times we're talking about real estate. Landon talked about this earlier. So a lot of times we give away our house and we really like to do that to a trust, because even though you might be healthy today and think you don't need long-term care in the next 5 years, we don't know what's going to happen. So let's say we gift our property to an irrevocable trust, the asset protection trust. The fair market value of the property is $200,000 and you need care within 5 years. The state of Pennsylvania is not necessarily going to deny your application for Medicaid. They're just going to impose a penalty. So they take the value of the gift, which again was $200,000. They divide it by the average cost of long-term care in Pennsylvania, which currently is $10,732.83. And that's 18.6 months. So for 18 and a half months, the state of Pennsylvania will not pay for your long-term care. So what does that mean? That can mean a couple different things. So let's say, next slide, Landon. I don't get to boss Landon around very often, so this is nice. So let's talk about different ways this could look, because it could look a lot of different ways. So let's say we gifted this property that was valued at $200,000 in November of 2014. But we have to move into a nursing home in 2018. So that's only 4 years into the look back. So we didn't quite make it through the 5 years. But remember, the gift of $200,000 creates a penalty of 18.6 months. So 18.6 months is more than 12 months, which is what is left in the penalty period. So my recommendation at this point in time is, okay, we need to pay through the rest of that penalty period. So we don't want it to be 18.6 months when it only has to be 12 months. So your question is, okay, but how do I pay for that 12 months? So one of the options would be, well, if you have other assets in your name, like an IRA, as Landon mentioned earlier, which is a little bit more difficult to protect, we would use that money at that point in time to pay for 12 months, knowing that you're going to protect your real estate. But let's say you have no other assets in your name, you don't know what to do. So there's some options. So the trustee of the trust could take a loan against the trust to cover the 12 months of care. So an example of that is, yes, we're going to have to pay some of the money out of the trust to cover that care because we didn't quite make it through the 5 years. It happens sometimes. But realistically, if $10,000 a month is your care cost and we only have to pay for 12 months, that's about $120,000. But you're still protecting money. There still could be about $80,000 that you can protect. So you aren't protecting as much as you had hoped, but you're still protecting assets. This is why the trust is so important and why we use them when we do gifting, because we can get money back from the trust. We can take a loan against the trust. We can't necessarily always do that against your children, because your children could have spent the money. They could decide they didn't like you anymore, and they could decide they don't want to do that. So then you're in a situation. And, something we didn't talk much about is there is also a Filial Responsibility Act in Pennsylvania that says, and this is another reason we don't prefer to gift to children. Because if you give something to your child and then you need care sooner than expected and there's no money to pay for it, but Medicaid's not going to pay, the nursing home can actually sue your children for non-payment. And most of us don't want our children to be sued to help pay for our care. So that's where the trust can add an extra layer of protection. Okay. So I'm going to give you a couple other scenarios. And by all means, I know I'm throwing numbers out there. I know some of you can't see these too, so I'm trying to explain them well. It's confusing. This is a lot of number crunching. Landon always jokes that he does like the legal stuff. I take care of the number crunching. It's just, I'm used to it. I do it. So it can be overwhelming. But again, this is why we offer that free initial consultation for you to come and sit down with us so we can talk to you about your specific situation. So this scenario here, let's talk about Harry. So he has a home that's valued at $200,000. He also has assets valued at $400,000. So in 2012, he put his home, which remember is valued at $200,000, and also $300,000 into a trust. Now, just to touch base on, you'll see that even though he's $400,000 in assets, we only put $300,000 in a trust. The reason for that is because we don't want to tie up all your assets into an irrevocable trust if you don't need care at that point in time. We like to be as aggressive as you feel comfortable, but we also don't want to put bank accounts that you need to, go out to dinner, go to Target, go on vacation. So we left $100,000 in his name. So that was in 2012. So in 2018, Harry has to go to a nursing home. So this was actually a fantastic scenario because he made it through 5 years before he needed care. He actually made it 6. You only have to make it 5 years in one day. So since he made over 5 years before he needed that long-term care, the house and that $300,000 in assets that he put into the irrevocable trust are completely protected from the cost of long-term care. He doesn't have to pay them towards the cost of his care. They're not available after he passes away for the state to come back and collect on. Those assets are protected from his long-term care costs. So that's a perfect scenario. And trust me, not every situation's perfect. We never know. But let me talk to you about a different scenario when we didn't actually use a trust. So this is John. So John, pretty same situation, $200,000 home and $400,000 in assets. He didn't do any type of planning. So now John needs nursing home care. The home and his assets are available for his nursing home care. So just to clarify on the home, when an applicant for Medicaid qualifies, your house is actually exempt while you're living. However, after you pass away, the state of Pennsylvania will come back and claim against your home to the extent they've paid for your care. So if you lived in a nursing home for a year and you have a $100,000 balance that Medicaid paid, the state of Pennsylvania will claim $100,000 on your house after you pass away. So it's really important that even if the only asset you have is a home and you didn't do any planning and you move into a nursing home, you need to talk with an elder law firm to make sure that we can protect that home for whoever you want that to be protected for. There's options. And along with this kind of discussion right here is, so we say all of this is available, and it is, but there are options. Even after you move into a nursing home, there are things that can be done to protect assets. Now, what we didn't talk too much about today, but those of you that have been on other seminars with us, is your powers of attorney. And I'm not going to dive too much into that, but to make sure to be able to protect this amount of money that we're talking about here and your real estate, you have to have really good powers of attorney. So you really need to make sure if your powers of attorney were not done by an elder law attorney. And when I say an elder law attorney that does this all the time, not your divorce attorney down the road that advertises they do elder law. You have to make sure there's certain provisions in your powers of attorney So you're never stuck, because if you do not have the ability to update your powers of attorney, your agents could be really in a bind, and they might have to petition the court to be able to protect any of your assets, or just not protect anything, and they're all vulnerable to your long-term care. So if you're curious about your powers of attorney, again, that's something that Landon and I can do anytime you schedule an appointment with us. We'll look at those and make sure they're in good order. Okay, Landon, what's next? Okay, so that was a crash course in Medicaid. I know there's a lot left to be said about that discussion, but we definitely wanted to focus on the trust today. But what is really important to talk about too is like, when should we really think about doing these trusts? Because there's different points of time. So one, if you or your loved one are moving into a nursing home in the near future, or have just moved in, you need to call us right away. So one thing that happens often is somebody moves their loved one into a nursing home, and they go, well, we have 100 days of Medicare coverage. Unfortunately, Medicare very rarely covers 100 days. It's up to 100 days, and we generally see more about 20 days of coverage. So it's a big surprise to the family when you get called into a meeting after 20 days and they say, Medicare ends in 2 days, you owe us $10,000 for the first month. So the quicker that you get in contact with our office, the quicker we can move to protect assets. A lot of our pre-planning clients are really individuals who have dealt with this with a loved one. So they worked with their mom and dad that have lost everything to Medicaid or the nursing home, or they worked with us and we were able to protect everything from the nursing home. But if you have any type of health condition, health issues, or you have assets that you want to protect for your legacy, that's when you need to come in and talk with us, because we can help you with that. We can figure out what your best options are. Okay, what else do we have here, Landon? I got behind on my slides. Oh, so, yep, as we already talked about, don't wait till the crisis, but even if the crisis hits, we can still help you. That's not a problem. That's what I do every single day. We work as quick as possible when we're dealing with crisis situations. Okay. And I did want to mention, so we're kind of getting to the end of our seminar, but Landon and I are really excited for our next seminar that's scheduled. And there may be one in between, but it's on July 21st at 4 o'clock. And this is the first seminar that we've done like this. It's called Wine and Wills, and we're very excited. So we want to, put that out there. If you're on our mailing list or email list, you'll be receiving information about that. So we're going to have a very, very casual, laid-back conversation. And bring your bottle of wine or your drink of choice, sit outside on your patio, and we're just going to have a nice conversation and answer your questions about anything. It's titled Wine and Wills, but it can be about anything. As you found out in the last hour and 15 minutes, Landon and I love to talk, and we'll talk to you about anything, answer any questions that you have and talk to you about anything. So at our office, as I mentioned, we offer the free initial consultation. We have a team of attorneys, we have certified Medicaid planners, like myself and Tammy. We have a really great team of support staff that were really knowledgeable about how this works. We focus on the second half of life planning, so we can be able to keep up on all the law changes and how this works, so we can advise you in the best possible way. Everything we do is individualized. Nothing we do is cookie cutter planning. Everybody's plan looks very different, so we can make sure we're doing the best job for you. At the end of the day, the peace of mind. A lot of what I do here at the office is really hand-holding. I'm walking you through the process because I know the Medicaid process is complicated and I do it every single day. So I can't imagine how overwhelming it may be for you that have never had to deal with it before. So even though with COVID-19, we're still taking every precaution possible because, of course, we're dealing with the most vulnerable population, and we want to make sure we're keeping everybody safe. So we're still doing our initial consultations by phone or by video using Zoom. And, you know, essentially at some point in time, we'll get back to face-to-face meetings. But I have to be honest, and I think Landon can say the same. It's the same quality services as at a face-to-face meeting. Everything's going great. I've actually learned a lot through using Zoom. I actually think it's going even better than those face-to-face meetings and the things that we've learned going through this process. After we have our initial consultation, if you guys decide to use us for any type of services, whether it's legal documents or crisis planning, Medicaid, whatever it may be, you know, we have a new process in line and it's working out really well. We're making sure everybody's comfortable with everything. And again, keeping everybody safe and keeping that peace of mind in place.